Please be seated. The sitting is open. The court meets this afternoon to hear the second round of oral argument of the Islamic Republic of Pakistan. Before giving the floor to Mr. Qureshi, I shall invite Judge Ad hoc Jilani, who, as you see, has joined us this afternoon, to make the solemn declaration provided for under Article 20 of the statute, which applies also to judges ad hoc. However, in accordance with custom, I shall first say a few words about his career and qualifications. Mr. Jilani, of Pakistani nationality, obtained a bachelor's and master's degree in political science from the former Christian College in Lahore, before obtaining a Bachelor of Laws at the University of Punjab. He began his long career as a district court lawyer in Multan in 1974 and was subsequently admitted as an advocate of the High Court. In 1983, he was admitted as an advocate of the Supreme Court of Pakistan. In 1993, he was appointed Advocate General of Punjab, having already held the post of Additional Advocate General. During his practice in law, Mr. Jilani held various elected offices, including Secretary General of the Multan District Bar Association and member of the Punjab Bar Council. After many years as a high-level legal advisor to the government, in 1994, Mr. Jilani became a judge of the Lahore High Court. He was appointed judge of the Supreme Court of Pakistan in 2004 and served as Chief Justice of Pakistan from December 2013 until his retirement in July 2014. Mr. Jilani has participated in many international conferences and has received various awards for his work in promoting the rule of law. Mr. Jilani also serves as an honorary co-chair for the World Justice Project, an international civil society organization which works to advance the rule of law around the world. I shall now invite Mr. Jilani to make the solemn declaration prescribed by the statute, and I request all those present to rise. Mr. Jilani, you have the floor.
I solemnly declare that I'll perform my duties and exercise my powers as judge honorably, faithfully, impartially, and conscientiously. Thank you.
Please be seated. I take note of the solemn declaration made by Mr. Jilani in accordance with the statute and rules of court as judge ad hoc in the Jadhav case, India versus Pakistan. I now invite Mr. Qureshi to take the floor. You have the floor, sir.
Mr. President, honourable members of the court, may I begin by saying how pleased I am to see Ad hoc Judge Jilani join the bench in the course of these proceedings. These proceedings are at the end, and I remind myself that the court provided the parties with an opportunity through the second round of oral pleadings to succinctly reply to the arguments that had been advanced against them in the first round. And I note, with regret, that India did not, in fact, reply succinctly or otherwise to my arguments, but instead continue to do what it has done with respect throughout, namely to distract, to affiliate, and to invade in the hope that it can shift the spotlight away from its own unlawful, and I regret to say, abusive conduct. India failed to engage with any substantive argument substantively. Instead, India criticized Pakistan for not embracing studied moderation. I'm not quite sure what that is. In response to India's repeated exertions from truth and reality to the realms of, with respect, irrelevance, fiction, and I'm driven to point out, falsity. India told the court that Pakistan should have refrained from using words such as ridiculous and nonsense in response to the approach adopted by India. Those words were unfortunate, but those words were unfortunately required and were given meaning by the context created by India, not Pakistan. Even in this regard, India could not stop itself from exaggeration, even on the very simple issue as to which words I had used and how frequently. Sadly, as the court will see at Annex 1 to my written submissions, I have identified that, in fact, I only used the word ridiculous twice, whereas my learned friend contended I'd used it 4 times. I used the word arrogance twice. My learned friend contended I used it 4 times. But the winner in terms of the reality and what was presented before the court was nonsense. I only used that word twice, not 5 times. And I am sorry to say that I had to use it, but as the court will recall from the content of the counter memorial and the rejoinder, various issues were raised which India simply failed to engage with. As for its own reply submissions, Pakistan has no need to add padding. The facts speak loud and clear by themselves. Indeed, India's attempt to drown out the truth with background noise simply will not work. And therefore, Pakistan intends to be brief and succinct in its reply, in accordance with the very helpful direction given by the President. That's because India has made no arguments, substantive or otherwise. What has happened, and I am compelled to point out, is that there are yet further examples during the course of the oral pleading yesterday of contumelious conduct in the guise of reply. There were nothing of the sort. In addition, yesterday, India demonstrated its abject failure to engage with the evidence that states made an exception for espionage prior to the Vienna Convention being adopted in 1963. That state practice was unaffected by the Vienna Convention, and I heard not a word as to why Dr. Sen, in writing in 1965, 2 years after the Vienna Convention, was wrong in recording that state practice reflected a frequent exception to consular access in the case of espionage. Indeed, now, India is in fact driven, as it must, to deny efficacy, meaning or relevance to a decision of the Peshawar High Court handed down on the 18th of October 2018. It is a clear and robust example of the High Court of Pakistan exercising effective review jurisdiction, as is required, not least by Article 199 of the Constitution of Pakistan. And there simply is no basis to contend otherwise. And in the course of my oral submissions, which are reflected in the written submissions handed in, and the page numbers are at the top, I'll address to begin with the conduct and 6 facets of India's conduct, which I'm driven to address because I am before a court. I'm not before the Commercial Court of England and Wales. I'm before the most august court on this planet, the International Court of Justice. And it's very difficult to confuse the two, Anybody who's visited the Commercial Court of England and Wales or has practiced there, as I have, cannot but recognise the majesty and splendour of this building and the modesty and the efficacy-based construction of the Commercial Court of England and Wales. However, it would be ironic, would it not, that standards are lower in this court than they are in the domestic courts. So I shall allude to the approach of India as most recently reflected with regards to the 2008 agreement, firstly, the military law experts report, the secret report. Then I must try and understand India's obsession with the Lahore High Court Bar Association, which appears to provide a catch-all, embrace-all justification. The double standards that India has engaged in are evident from its own submissions as late as yesterday. Then the kidnap fiction. Why? Before I turn to the substantive issue, so far as we're concerned, because India's conduct, as most states behave decently, should never have featured before this court. And I, as an advocate, have had to draw attention to it because I'm compelled to draw attention to it, because it's my duty to the court to draw attention to it, not for any other reason. The Vienna Convention and the espionage exception and the approach of India to it has been developed yet further as of yesterday. The relief sought, the review and reconsideration, which has been established as the relief in the event that there is a breach of Article 36 of the Vienna Convention on Consular Relations, is a matter that India's submissions bear considerable scrutiny upon, because they seek to distance themselves from the position of this court, stated again and again by some degree of subterfuge, by in effect asking this court to become a court of appeal, a role it has disavowed for very obvious reasons since the Paraguay case of 1998 and subsequently. And I'll end with my concluding remarks. But to begin with, India's conduct is in fact no surprise, because India, in its own pleading, made it very clear that neither the nature of the charges nor the conduct of the sending state is relevant in examining the allegations of the violation of Article 36. Now, when I look at the Vienna Convention shortly, we'll see that that patently is inconsistent with the Convention itself. But this mindset provides the explanation for India's entire approach in this matter, as we shall see, and as was demonstrated all too clearly yesterday. And I'm compelled to point out that this is a mindset that one finds in fiction, indeed in Wonderland, because India, yet again, demands words mean what it says they mean, and that its deliberate addition and omission of words to text must be seen as mere interpretation. Not as anyone in the real world would see it, namely, unashamed alteration. There is a distinction, a linguistic distinction, a distinction of effect. And I agree with my learned friend. Characters from Wonderland have no place in this court, not least the rotund character with a fragile cranium. But Pakistan is not the state that brought that character into this court. Pakistan is seeking to banish that character from this court. And we are confident that the approach that this court adopts to the English language is that of the real world, and not of some faraway place of fiction. The 2008 agreement, India stated yesterday that its case is simple. That is true. It's simply wrong. It is to deliberately misread Articles 6, 5, and 7 by joining them together through an abuse of punctuation and grammar. I understand from my friend that India shirks from and finds language such as the phraseology of abuse distasteful. But I venture to suggest that it's very difficult to find any other language or any phraseology other than abuse when one looks at the addition that took place to a text negotiated between India and Pakistan over 3 years, in the aftermath of the negotiation, 10 years later, namely the addition of a comma and 2 words to draw a conclusion that, in fact, the approach that India was adopting was not alteration, it was interpretation. It is not, as India puts it, simply a matter of law, and it cannot, with the very greatest of respect, yield a response of studied moderation, whatever studied moderation is. India, with respect, did not demonstrate abatement at this juncture, because what we were told yesterday was that the report of the military law experts is now irrelevant and should be completely disregarded. As the court is aware, there were strenuous efforts made by Pakistan from May 2018 onwards to seek correction of India's mischaracterization of the contents of the military experts' reports. Those efforts were to no avail, and it would seem from the submission that was made yesterday that on India's position, it had no duty to ensure that its pleadings or annexures were accurate. And it would seem on India's position, as of yesterday, its counsel has no obligation to do so either. My friend pointed out that Pakistan's pleading, in contrast to India's, was signed by counsel. That is absolutely right. Why? Because a member of the English bar, as I am, I take responsibility for the contents of a pleading and the accuracy of the facts therein. And I'm perfectly prepared to be held accountable because those facts are unimpeachable. I challenged India to identify any discrepancy, any inaccuracy in those facts, and there wasn't any. That is the reason why parties are held to their pleadings. Otherwise, what is the purpose of certification of pleadings? Is taking full responsibility, as the agent for India said yesterday, devoid of content, devoid of consequence? Is this a court where it's possible to advance a case and then retract based upon inaccurate, if not misleading information? How can that be the case? Because if it is, then the only conclusion one can draw is that professional ethics are to be left at the door of the Peace Palace. That simply cannot be correct. That simply cannot be correct. Indeed, it's quite clear that after the military law experts' report was filed on the 13th of December 2017, in its reply of 17th of April 2018, India was more than happy to refer to and adopt the military law experts' report. Of course, after having, as we say, doctored the report, it did not just refer to it, it enthusiastically embraced the report as being supportive of its conclusions, because it said, in the reply at page 53, para 155, this report of the experts hardly supports Pakistan's challenge to India's position. On the contrary, the court now has a report filed by Pakistan which substantially confirms what India has said about the failings in the system of trial by military courts. So from India's perspective, as at that juncture, it was relevant. However, as a result of no less than 3 subsequent communications by Pakistan, including myself to my friend, which I'm very disappointed to learn was considered a veiled threat. I'm very disappointed, because what I had asked was, given that the ICJ hearing commences on 18th of February 2019, I hope you'll be able to fully explain or correct matters promptly by letter dated 7th of February. And was that such an unfair, onerous, unrealistic request from one professional to another? Was that such an unfair, unrealistic request on behalf of a state which had sought as a matter of courtesy to extract a correction? Because what's being said now is that, firstly, by adding the word "the" by, we're told, mistake, given that we'd asked you on at least 3 occasions before the 18th of February to check and to identify errors, and we'd drawn what you describe as errors expressly to your attention, and you decided not to correct them, which makes the conclusion of mistake ever so slightly more problematic, that adding the word "the" by mistake to arrive at a conclusion based upon what can only be described as doctrine, and secondly, omitting the word "often" as a result of what we're told was a paraphrase, could not possibly be matters for concern. Indeed, it was said yesterday that Pakistan was being presumptuous by suggesting that this court will not identify the error, discrepancy, typographical mistake, simpliciter that India had been responsible for. Not so much as an apology, not so much as sorry. Is it that difficult to accept mistakes? And then we're told that the addition of the word "the," as well as ignoring the word "potential" and omission of the word "often," do not change the sense of what is said in the report and are matters of interpretation. Now I ask myself, how can this invite a response of studied moderation in the real world, the language that my learned friend was imploring me to use, studied moderation? How can a response of exasperation be avoided in the real world, where real people rely upon words to have meaning and effect which is objectively ascertainable, not meaning that moves, subject to the whims of the user of the words? Furthermore, as is quite clear from the conduct which I'm compelled to point to the court, India had engaged in 4 opportunities to at least do the decent thing and tell us we got it wrong, assuming that was the case. It seems that India maintains it had absolutely no duty to respond to requests made in the interests of accuracy and clarity to effect correction until it saw fit. Until it saw fit in the oral round to advance the wholly implausible explanation of typo and interpretation. Yet, how is Pakistan supposed to respond to this approach? With those wonderful words that my learned friend has aped, and we'll see from where, studied moderation. Well, I'm sorry if I was not able to moderate, and I'm sorry if after many hours of study of those words, I had to draw the conclusions that I did, and I don't shirk from those conclusions. So far as the military law experts are concerned, India is at pains to point out that this is a case only about denial of consular access to Commander Kulbhushan Jadhav. Far from it. The memorial, the counter-memorial, and indeed this massive material that was placed before the court yesterday make it very clear that India persists to the very end in seeking to distract and deflect attention from its failure to answer critical questions by levelling, with respect, baseless allegations against Pakistan. Allegations that this court should not even countenance. Not just because they're utterly devoid of evidential basis, but they're based upon materials that India has been forced to add to its reply as what I would describe as bombastic ballast, with no other value in these proceedings. And that material, that padding, has no bearing on the issues before this court, save that that material and the contents of the file that was put before the court yesterday continues to provide confirmatory evidence of India's overall approach, even at the end of these proceedings, to deflect, to distract, and ultimately to evade. I come to the secret report, and we see a pattern developing on the part of India. And it is as follows. A document was adduced as an annex to the reply, a 7-page document which purported to be dated the 26th of December. And it underpinned approximately 15% of the reply, 15%. When repeatedly pushed by Pakistan, India rebuffed all requests to check the accuracy of the reply soon after it was filed. Now, I'm compelled to point these matters out because they are relevant, because these proceedings don't exist in a vacuum. However, yet again, because it was compelled to, when Pakistan made it clear that it intended to expose the manufactured nature of the document, and I use those words carefully because on Tuesday I identified 6 respects in which that document can be undermined. And I'm sorry that JP Singh is not here, because it would have been important to illustrate that undermining. What did India do? It sought to effect a correction to the date of the secret report on 23rd of January 2019, with reference to a letter purportedly dated 8th of August 2018. Presumably, how? As a slip error to the date of the said document. But of course, there is a rule which provides for corrections. Article 52(3) of the Rules of the Court. But corrections can only be made with consent of the party or leave of the President. That wasn't sought. This was a document that was introduced. And that's consistent with India's approach, because, with respect, it believes it has no duty to ensure accuracy in its pleadings. It believes it has no duty to effect timely corrections. And, worst of all, it believes that there are no consequences for its blatant inaccuracies otherwise. And now what happens is ultimately India now contends that even this report is irrelevant. India has to accept, because it placed this document before the court, that it believed it was relevant when it filed its reply. And it was obviously intended to have evidential effect. However, once the inaccurate, if not manufactured, nature of the document was laid bare, India's answer was simple. It was now irrelevant. Then we come to the Lahore High Court Bar Association, and I can pass by this very shortly, because it seems very simple. In its desperation and total disregard for the truth, I'm sorry to say, and I apologize for using these words, but they're necessary. So the apology is sincere, but it's only because I'm forced to use the words that I use them. The facts compel me to use them. India is reduced to equating words allegedly attributed to the secretary of a provincial bar association with the formal position of the Islamic Republic of Pakistan. Now I ask myself, mercifully, it wasn't the president. How is this not risible? Double standards are unedifying, but when witnessed in a party's conduct, they must be commented on. Yesterday, we had an interesting insight into this approach. India asserts at one and the same time that Pakistan failed to comply with 18, and as I have pointed out in my written submissions, 5 pages later in its reply, that jumped to 40 MLA requests, and also contends at the same time, at one and the same time, that when it came to India itself, it had no obligation to comply with the requests made by Pakistan to it on the 23rd of January 2017, because there was no bilateral treaty, no mutual legal assistance treaty. Now I ask myself, how do double standards manifest themselves? Generally, by a party demanding behavior towards it, which it is not prepared to show to others. That isn't how states are supposed to work, and that is certainly not the behavior that this court should countenance of any state. Yesterday, in oral submissions, India said it believes its figure was correct, without specifying which figure, until eventually the court was told to assume that 18 MLA requests had been, the wonderful phrase, mentioned in passing by India. Mentioned in passing by India. Yet another example of trying to turn down the volume on a point that had been made with some force conviction to begin with, but when the point was analysed, its efficacy was diminished. It recedes into the distance, into the dim and dark distance, because it's replaced by deflection. Another example of deflection. It was asserted yesterday that the court had been shown photographs, plural. This is not a matter of interpretation. Photograph, single, photographs, plural, of high functionaries. Singular or plural? Plural. And was told that an investigation into their conduct was sought by Pakistan. Just one photograph was shown of an Indian person, namely Mr. Ajit Doval, India's self-styled super spy. There was no suggestion made that Pakistan had sought an investigation into his conduct. However, what's illuminating is that the speech of February 2014, as reported in 2016, was not denied. The accuracy of that speech was not denied. I had said in my submissions on Tuesday, perhaps half expecting it to be realised, that Mr. Doval might well come to court to explain to the court that the speech had been an incorrect attribution to him. He didn't. If Mr. Doval happens to visit London at any point in time, I understand there's a vacancy for the actor to play James Bond. He may well come and tell me exactly whether that was correct or not. But the brutal reality is that even if he hasn't been made the subject of an investigation, the words that he hasn't disavowed and India hasn't disavowed surely provide the murky context for Commander Jadhav's actions. They provide the context, the background. They chime with all of the other material that I'd placed before the court. This isn't fiction, this is fact. Lest there be any other doubt, and the memory of my friends for India is unclear, there was only one other photograph that was shown to the court, and it was this. Definitely not an Indian national, a German national. And we move to the kidnap fiction. Why, oh why, is it necessary, yet again, to engage in fiction? I mentioned Dr. Mittal because Dr. Mittal was, of course, the individual who was fielding, rather perhaps unfairly, because he was also the agent in these proceedings, and definitely unsuccessfully, questions from Indian journalists in a press briefing where Indian journalists, on no less than 4 occasions, asked why President Rouhani of Iran had not been the subject of questions, queries relating to Commander Jadhav. And the court will recall that Dr. Mittal was at pains to close that line of questioning down. Now, a failure on the part of a sovereign state which places pleadings before this court and says it's respectfully submitting to this court, signed by its agent, that it reasonably believes that Commander Jadhav was kidnapped from Iran, ought to try and make a little bit of an effort to put some information before the court as to the steps it's taken. But what are we left with? This fiction is left completely unexplained. Why? Well, very simple. Because providing an explanation would expose the fiction. Then we turn to the 3 independent Indian journalists that Pakistan had referred to illustrate that their independent investigations, at the very least, corroborated Commander Jadhav's own confession of being a RAO agent. And I'm not going to give the court an insight into what's been happening so far as social media in India is concerned with regards to these 3 brave individuals. But what was the riposte? India's response was to assert that Pakistan had used the words clinching and convincing, as well as unimpeachable, to describe the evidential value of the investigations made by the journalists. Whatever words I may have used, credibility, corroboration, I never use those words. Those are words apt to be used by an adjudicative tribunal, judiciary, not me, not an advocate. And therefore, Pakistan asks, how can India's approach be anything other than wholly improper? How can it be to play fast and loose with words in this way? And how can it be that yet again we have another example of inconsistency? Because, perhaps unwittingly, India says the following, and it's not yet explained it, because we asked for an explanation. In paragraph 92 of its own pleading, its own reply, it adopted the following position. What was the other evidence, apart from the patently contrived confession and forged passport, from which it could be established that Yadav was engaging in acts of spying and terrorism? Interesting revelation into the insight of the pleader, whoever it was. Other, apart from, two material sources are identified, and the passport is one of them. And of course, now what India has said about the passport, we shall see. It's rhetoric, and in any event, the issue has no legal consequence. Well, with respect, we say it does and it must. And I ask myself, and I ask the court, is it permissible for a party to chop and change, to move around its case without consequence? Is it possible for a party to advance material which is supposed to have the quality of evidence, and then when challenged, not just to diminish its presence, but to discard it as being totally irrelevant? India says, and I use the word assert, and I don't mean any offense by saying assert, because an assertion is a proposition advanced without any foundation, substance. And this is a proposition advanced without any foundation and substance. It asserts that there was no need to address the passport issue, as this had no legal consequence. And Pakistan's submissions were mere rhetoric. Submissions, which, as the court was shown, were based upon clear, compelling, uncontradicted evidence, which was described as the evidence of a purported expert. That was how it was diminished, sadly. A purported expert. The gentleman who trained the Indian authorities for 3 years, been the head of the National Fraud Detection Unit in England, was a purported expert. The gentleman who'd viewed thousands of passports was a purported expert. So India moves from that position to say, well, in any event, so what? It doesn't have any legal consequence. Your submissions are mere rhetoric. And then yesterday, we were told that, in essence, it seems that even if he sneaked in using the passport, so what? Well, is that what we're left with? So what? The suggestion that India's conduct in this regard has no legal consequence, if accepted, is a suggestion that I would invite the court to pause upon. Because if it's accepted, it would allow a serious transgression of the duty of good faith. Never mind fundamental international obligations to be untrammeled upon and violations to go unchecked. So then we turn to the approach that my learned friend suggested that India was adopting, which was to hammer the facts, hammer the law. And here I can tell the court, I agree. I agree that's exactly what India was doing. It was hammering the facts such as to twist them, and it was hammering the law such as to break it, to suit its purpose. And India's conduct cannot go unchecked. It must not go unchecked. This is the court of the international community. This is the court of the United Nations. This is a court that's been furnished with evidence, not fiction, not fantasy. Pakistan's position has remained firm throughout, based upon that evidence. The only party that's been distancing itself from its own evidence and trying to diminish its effect is India, by describing its own evidence as ultimately irrelevant. The espionage exception. The proposition that was advanced yesterday by my friend, I've sought to encapsulate in the first proposition, because what's said is as follows: even if an individual agent, the word that was used by my friend, not me, of the sending state has been properly charged with espionage activity, properly charged, not fictitious, trumped up, on behalf of that state, the denial of consular access would constitute the introduction of an impermissible limit or exception into the language of Article 36 BCCR. And again, I'll interpret India's position, and I respectfully observe that the court is invited to interpret India's position, because in my humble understanding of the English language, what it means is that on India's understanding, even if there is a case to answer, no matter how serious of sending state complicity in seeking to undermine the territorial integrity of the receiving state, or blatant violations of international law otherwise, on India's understanding, that is totally irrelevant. It's a submission which is plainly wrong, however convenient it may be. Because unless India is contending that Article 5A of the Vienna Convention on Consular Relations, which enjoins state parties to comply with international law, or that Article 55, which prohibits interference in the internal affairs of the state, have no meaning, then we're left with a situation where it's difficult to comprehend the position being advanced. Unless, of course, one remembers India's core stance. The behavior of the state is irrelevant. That cannot be right. And then yesterday, yet again, my friend invoked the language of exhaustive rubric. Flowery language, but how is it reconciled with the interaction between Mr. Tunkin and the chairman of the drafting conference in the context of the language relating to delay, temporal limits within which consular access could be denied? The chairman's response was as follows: a statement of general principle of law could not possibly cover all conceivable cases. How can the two be reconciled? Is this a matter of interpretation? Yes, it is. Because if one embraces India's approach to language and ignores all other evidence, then India arrives at the conclusion that the words that the chairman was using chime with its understanding of an exhaustive rubric, a statement of general principle which could not possibly cover all conceivable cases, is an exhaustive rubric. Well, I have to confess, I've not been able to reconcile the two, but I'm very pleased that India in its own mind has been able to. I doubt very much if the other 177 state parties would agree. But they're not here. And the only point that I was making to the court was not that the absence of the 177 state parties somehow provides me with invisible support to my submissions. On the contrary, the position that I advanced before this court with reference to state practice from the 1930s was that states adopted a position of what I described as studied ambiguity. They were careful to ensure that the position they adopted here was ambiguous. And that has remained the case. When one looks at the travaux and the discussion of the Vienna Convention on Consular Relations, that's clear. When one looks at state practice, that's clear. But then I realized that my learned friend's use of the phrase studied moderation seems to have been directly linked to my use of the word studied ambiguity. Well, if I'm right, then I understand that imitation is the sincerest form of flattery, and I'm obliged. But while studied ambiguity makes sense, with respect, the English language that I'm familiar with, studied moderation in this context simply does not. And then India contends that Pakistan is suggesting that Article 36 of the Vienna Convention on Consular Relations should be read down to exclude espionage, that the provision itself ought to be interpreted in a manner which enables an espionage exception to be carved out from it, if customary international law did not have a consistent practice of allowing consular access in such cases. That is simply wrong. The preamble to the Vienna Convention on Consular Relations makes it clear that the position that customary international law was unaffected in the absence of express provisions to the contrary in the VCCR. Indeed, lest we've forgotten, the preamble provision stated as follows: affirming that the rules of customary international law continue to govern matters not expressly regulated by the provisions of the present convention. I, for my part, with respect, read that as being clear and simple, because it provides that in the absence of a consistent practice of allowing consular access to espionage suspects, it's the absence of that which constitutes the customary international law basis for denial of the same. There's absolutely no need to read down Article 36 of the VCCR. Not content with using the language of reading down, which those of us who are familiar with statutory interpretation will understand, we move on to crystallization. So we have fertilization, we have reading down, and now we've moved to crystallization. Because India wrongly suggests, I'm sorry to say, that the preamble to the VCCR crystallized prevailing customary international law. It didn't. On the contrary, what did it say? The rules of customary international law continue to govern matters not expressly regulated by the provisions of the present convention. And then we move to the relief sought, review and reconsideration. The court was treated to an interesting exercise in distinguishing and negating judicial precedent. We're all familiar with the basic proposition, one hopes, that a judgment of a court is binding until a superior court states otherwise. But the position that was advanced by India yesterday, I say again with respect, unabashedly, was that Pakistan was not relying upon the recent judgment of the Peshawar High Court dated 18th of October 2018 in the Abdul Rashid case. Well, of course, it hadn't been an annex to the counter memorial of December 2017, and it hadn't been an annex to the rejoinder of July 2018 for one very simple reason, because Pakistan understands chronology. Whilst documents headed secret can be backdated, the reality of the matter is that this judgment was handed down on the 18th of October 2018, and it's publicly available. It's a 170-page judgment, and we had no qualms about bringing it to the attention of the court in my written submissions. But in fact, what India said yesterday was that Pakistan has not offered an explanation to the court as to why these are the words that were used yesterday, my written submissions identify the passages in the transcript, and I'm driven to have to draw these to the court's attention. I wish I hadn't the duty to do so, but I do. And it bears heavily upon me, but I must discharge it. India asked why Pakistan had not offered an explanation to the court as to why Pakistan, did not rely upon the judgment if it supported its case. And I must confess that's a bizarre proposition, because it would appear that this is a proposition that can only be advanced if, with respect, India had closed its eyes as well as its mind, because the very screen that I'm looking at right now gave clear and express reference to the judgment in the PowerPoint presentation, and I made sure, unless I've acquired salinity over the past 24 hours, that I made reference to it in my oral submissions. India didn't stop there. India further asserted that Pakistan was concealing. Use of the word concealing. It's a very heavy word. I'm told that I should be very careful about the words that I use, but it seems that it's okay, it's all right, it's acceptable. In fact, it's justified for India to say that Pakistan was concealing the fact that the Islamic Republic of Pakistan had filed an appeal against the Peshawar High Court decision. Now, with respect, when the court looks at the slides that were before the court, page 48, second bullet, the court will see that that slide made express reference to the appeal pending before the Supreme Court. But yet, what's Pakistan supposed to do even now? I'm supposed to stand on a platform and maintain a position of studied moderation, whatever that means. When a sovereign state is being accused of concealing a fact, I'm supposed to stand here and say to the court that I agree I should maintain a position of studied moderation. Well, I can tell the court one thing, that what Pakistan has maintained throughout these proceedings is dignity. In the face of contumelious conduct on the part of India, which I'm driven again to remind this court of, what Pakistan has not done is allow itself to be provoked by tactics which are unbecoming of a state that identifies itself as the world's largest democracy. And in fact, the linguistic gymnastics that India has to engage in are of its own creation. Why? India said the following in its reply on the 17th of April 2018, that Pakistan, a sovereign state, did not have a procedure by which a trained independent judge. Now, I just pause there to see the nature, the startling nature of that proposition, that Pakistan, a sovereign state, did not have a trained independent judge, not a single one of them, who was able to dispassionately review the findings of a military court. That not only do they not have a single trained judge who is independent, but this individual is incapable of being dispassionate. Well, I'm sorry to say, as I said on Tuesday, that I would hope in due course the relationship between these two states can be one based upon comity, upon amity, with less heat, more light, more cordiality, more substance. But what's very clear is that the Peshawar High Court was able to address the questions before it, evidencing legal acumen, evidencing robust independence, evidencing objectivity. Indeed, the Peshawar High Court decision chimed with the observations of the experts, because the experts had clearly stated on the 28th of November 2017 that the High Court of Pakistan possessed an effective review and reconsideration jurisdiction. So, having said that Pakistan didn't have a single trained, it seems, independent judge who was able to set aside his or her prejudices to dispassionately review the findings of a military court, now that there is the Chief Justice of the Peshawar High Court, no less, sitting in a divisional bench with another High Court judge, what's the solution? Well, the solution that India has turned to on more than one occasion, to say, but the judgment has no value. It's irrelevant. Why? Because it's the subject of an appeal. Again, in all legal systems that I'm familiar with, civil law, common law, a court's decision is valid until declared otherwise by a superior court. Otherwise, the whole nature of precedent and legal findings would be thrown into chaos. But not in this case. In this case, what we're told is, let's ignore the decision of the Peshawar High Court. It has no value, it's irrelevant, because it's subject of an appeal. Does that mean that parties aren't entitled to seek appeal? Does that diminish the existence of an effective review and reconsideration jurisdiction in the High Court of Pakistan? How can it? And then we move beyond that by way of the materials that India served in its reply yesterday, a large file of documents, part and parcel of the scattergun approach of deflection. A problem arises for India, namely this, that India referred to a recent European Council resolution, even assuming that that had any relevance in this context, to assert that this resolution explicitly, now again, so far as I'm aware, the word explicitly means expressly, clearly, reflects concerns at the conduct of certain states in which Pakistan figures prominently. Now, my understanding of English, my simple understanding of English, tells me that to figure prominently means to be in amongst a list, but to have your presence accentuated, to have your presence drawn attention to, with regard to due process of law and fairness of trial. However, I regret, despite having read paragraph 9 several times, in the early hours of the morning as well, and recently, as opposed to what no doubt India will say was India's interpretation, it shows no such thing. There was absolutely no explicit or underlying reference otherwise with regards to due process of law and fairness of trial. So why use language such as explicitly, figures prominently? Is this part and parcel of what I said to the court on Tuesday? Is it a mindset of catch me if you can? And so far as the military courts are concerned, I ought to make it absolutely clear that notwithstanding the experts' report, notwithstanding the availability of effective review and reconsideration before the High Court pursuant to the Constitution of Pakistan, it is simply wrong for India to disparage the military courts of Pakistan as it has done. The rules of evidence and procedure are the same as in the civilian courts, with evidentiary standards, procedural rights, and the capacity to grant relief being substantively the same. The confession that is adduced as evidence in the military court is recorded under Section 164 of the Code of Criminal Procedure before the judicial magistrate in the manner as provided in the Code of Criminal Procedure and in accordance with the standards that apply otherwise. Indeed, the very same magistrate is called as a witness before the military court to give evidence as to the confession that he or she took. A confession that's taken in accordance with stringent safeguards. And India, with respect, is seeking to misrepresent the military courts of Pakistan. Not a single juvenile was tried and convicted by the military courts. And it's important to remember that Commander Jadhav was tried and convicted pursuant to Section 3 of the Official Secrets Act of 1923, which provides for jurisdiction in respect of espionage offences. He wasn't tried and convicted pursuant to the extension of the military court's jurisdiction in 2015, brought about as a result of the appalling atrocity whereby innocent children were massacred in a school in Pakistan, in Peshawar, more than 100. That's what prompted the extension of the jurisdiction of the military courts. And the carnage that has ensued in Pakistan over the past 10 years, which has been abated because of the considerable efforts and sacrifices of the forces of Pakistan, is a carnage that many of you on this bench and many in the room will be all too familiar with, and some have suffered personally themselves. So it's absolutely wrong, I would say improper, to have sought to castigate the courts of Pakistan in the way that India has done, to suggest that there's not a single trained independent judge who's capable of dispassionately reviewing the findings of a military court. I mean, that's what it comes to when you boil down the proposition. So I move, finally, to my concluding observations. And as I said in the counter memorial, and I apologized in the counter memorial, I apologized that I would have to use trenchant language, forceful language, that I was being compelled to use forceful language. It's not ordinarily the case that I use forceful language But sometimes situations demand language is used because it's necessary to convey the essence of the situation. Indeed, that is what language is meant to do. It is meant to enable us, with precision and accuracy, to convey. And it's meant to carry, with precision and accuracy and objectivity, meaning and effect. But the brazen distortion of the 2008 agreement and the doctrine of the military experts' reports were matters that even at the commencement of the oral phase of these proceedings, however incredulous it may seem to some, Pakistan was expecting India to show some respect, at least to the court, and if not to Pakistan, at least to the independent experts. An apology would not have gone amiss. That has not happened. And so we are here now in a position, so far as India is concerned, which is as devoid of legal merit as it was on the 8th of May 2017. In fact, even more so in the light of India's continuing conduct. I'm sorry to say, I regret to say, but I am compelled to say. And India's claim for relief remains as far-fetched now as it was then. And all of these matters are important because this court, the International Court of Justice, the World Court, stands at the apex of all judicial institutions. This is the court that provides the touchstone for conduct of states as amongst themselves. This is the court that sets the ground rules pursuant to which states engaged mostly decently and identifies, however reluctantly, when states have behaved indecently, because it's a difficult conclusion to draw. It's bad enough having to conclude that an individual has behaved indecently or abusively, let alone a state. But sometimes, very rarely, sometimes nevertheless, it's incumbent upon an adjudicative body to identify the facts and see them for what they are and express its position clearly, not just for the litigants in the particular case, but for the future, because the rule of law depends upon it. India's conduct has shown contempt for accuracy, I'm driven to say. And I've shown the examples. Its conduct is replete, even yesterday, and a total disregard for the truth, I'm sorry to say. But I'm not sorry to say the following. And I say it, as I said on the 15th of May, in the context of the Provisional Measures Order, and I say it again. India's claim for relief must be dismissed or declared inadmissible. Mr. President, thank you.
I thank Mr. Qureshi for his statement. I shall now give the floor to the agent of Pakistan, Mr. Anwar Mansoor Khan. You have the floor, sir.
Your Excellency, the President of the International Court of Justice, the Honorable Judges, before I start my closing statement, I must say that I'm extremely happy that Mr. Jilani has recovered and is able to attend to this court. At the close of the case, I would, as agent of the Islamic Republic of Pakistan, bring forward some crucial issues which are raised and were irrelevant to the case in hand. Very strong, uncalled for criticism has been made on the judicial system of the Islamic Republic of Pakistan in an attempt to show that it has no review or reconsideration process. Pakistan has a very robust judicial review and reconsideration system. May I say that the entire courts, whether regular, civil, criminal courts, special courts, specialized tribunals, or military courts are created through various acts of the Parliament as prescribed by the Constitution. The proceedings before any court are in accordance with the criteria specified by law, in force, and that it is true as to the procedure prescribed by law for trial before the military courts. Naturally, for reasons of state security, confidentiality, state secrets, some of the trials cannot be made public. This is true in almost all jurisdictions, including India. Article 4 of the Constitution of the Islamic Republic of Pakistan provides that every person shall enjoy the protection of law, and no action detrimental to his life, liberty, body, reputation, or property shall be taken except in accordance with law. And Article 10A of the Constitution of the Islamic Republic of Pakistan gives as fundamental right the right of fair trial without it being subjected to any law, where many other rights are subject to law. Thus, fair trial is an absolute right and cannot be taken away. All trials are conducted in that manner, and if not, the process of judicial review is always available. Mr. President, and the honorable judges, I need to remind my friends of the case of Afzal Guru. He was refused a lawyer, and the court appointed a lawyer, filed an application stating that Afzal wanted to be killed by a lethal injection. It is amazing that the Honorable Supreme Court of India, while absolving him from the charge of being a terrorist organization, but to satisfy, and I quote, the collective conscience of the society, upheld the death sentence. I asked them, is that a ground for conviction under the law or the Constitution? This is a fair trial in judicial review in India. Mr. President and honorable judges, I did not want to bring in the various contentious issues of India, but for unwarranted and concocted allegations. I need to make a mention of the Samjhauta Express. Terrorist acts where more than 42 Pakistanis were burnt alive. Pakistan has requested that the perpetrators be brought to justice, but no action has been taken. India has embarked on the process of exonerating the accused who have confessed to the carrying out of the heinous act. Families of thousands of Muslims of the Gujarat who were massacred in 2002 with full state connivance await justice. When we talk of the unfortunate incidents of Pulwama in India-occupied Jammu and Kashmir, India has become a judge, the executioner, and call themselves the victim. Without any evidence to show or any inquiry held, Pakistan has the right to ask for proof, to which India has no reply. May I now only refer to the atrocities committed by India without any recourse for victims. The Indian human rights have been a target all over the world. The Indian human rights have been targeted all over the world, and may I mention the use of pellet guns by Indians on innocent citizens of India in the Indian-occupied Jammu and Kashmir, where more than 200 innocent civilians have lost their lives, more than 15,000 have been injured, and more than 15,000 missing. More than 2,000 innocent men and women have been blinded for life by use of pellet guns. This includes 18-month-old Hiba, who would never be able to see in her life. Do we forget the rape of the young 8-year-old Kashmiri girl, Asifa Bano, of Rasana village in Katog? The UN report asked for inquiry, but of no avail. We also cannot forget the soldiers of 4 Rajputana rifle regiments having raped 23 women in Kanun, Poshpara village of Kupwara district of the Indian-occupied Jammu and Kashmir. Attempts to seek justice was denied by the authorities and the judicial system. According to the Human Rights Watch, the Indian Army courts of inquiry dismissed all the charges against 5 officers for the high-profile killing of civilians in India, Indian-occupied Jammu and Kashmir, demonstrate the Indian occupation forces continuing impunity for serious abuses. On 24th of January 2014, the Army said that it was closing the case for lack of evidence against the Army officers who were accused in March 2000 for extrajudicial killing in Chittagpura for 5 civilians and falsely claiming that the civilians were terrorists who killed 36 villagers. The Army blocked the case after it used the Armed Forces Special Power Act 1958 and was invoked to block the case brought by the Civilian Central Bureau of Investigation. India relies on the report of a private NGO, International Commission of Jurists, to discredit Pakistan. There are numerous reports of similar nature from the public domain against India. Some of them have been filed and available on the judge's folder. The findings of the private organization are being put forward to challenge the report of the qualified experts filed by Pakistan. The report filed by Pakistan is plausible and correct. The report of the Commission is unfortunately biased. I have dozens of other examples of lack of judicial review in the Indian judicial system. I need to explain that the judgment of the Peshawar High Court, which was rendered under Article 199 of the Constitution of Pakistan, the judgment of the Peshawar High Court allowed the petition on grounds of facts available were not sufficient to convict the 72 persons. The appeal to the Supreme Court was on the facts and evidence before the High Court, which was not fully appreciated by them. May I say that the military courts of our country are governed by the Constitution and by all statutes, including the laws of evidence, the Criminal Procedure Code, and all similar laws. Thus, saying that the military courts are for some reason incompetent and above the law is an incorrect assertion. I would also make it clear that the said Commander Yadav has been charged with terrorism for which a FIR has been registered with the police, that is a civilian agency. The military courts have sufficient proof of espionage, and the said military courts, on the available evidence and the judicial confession, proceeded to convict him, despite he being given the option of going for a judicial review. He has refused to do so. May I, Mr. President, and the honorable judges say with full authority that the system of judicial review in Pakistan are potent and very effective. The courts of law are extremely independent, only act on facts and the law without being influenced by any extraneous reasons. India claims consular access surely was not allowed for good reason in terms of the agreement of 2008, especially for the reason that Commander Yadav being involved in espionage. He was allowed to choose a lawyer for himself, but instead he opted to be represented by an in-house counsel / defense officer qualified for legal representation. Should he choose to enter into the domain of judicial review, he will have the right to choose his lawyer to represent him. I am the chairman, sir, of the Pakistan Bar Council, the highest body of the lawyers of Pakistan. I say that there is no resolution of Pakistan Bar Council to the effect as passed by the Lahore High Court Bar Association. The said Bar Association passing a resolution is within their own body. However, the Pakistan Bar Council is for Pakistan and overrides all bar associations. Mr. President and the honorable judges, India seeks relief which they cannot claim from this court. Seeking to release Commander Yadav, allowing him to proceed to India, or a direction of review and reconsideration. If it is the choice of the convict to seek a review and reconsideration. It is the choice which, if he seeks, will be given to him. I surely want to bring forth the fact that there is an FIR against him in the civilian domain, and that, in addition to the conviction so given, the case of terrorism is to commence against him. In addition, such a relief may not be allowed. Naturally, maintaining the judgment is essential till it is set aside by a court of competent jurisdiction in a judicial review proceedings, which he is advised to take in Pakistan. And finally, sir, the Islamic Republic of Pakistan respects the court for reasons set out in the Pakistan's written pleading and in its oral submissions made in the course of these hearings to declare India's claim inadmissible. Further, or in the alternative, to dismiss India's claim in its entirety. Mr. President, distinguished members of the court, to conclude our participation in these proceedings, I wish to extend on behalf of the Republic of Pakistan our sincere appreciation to you, Mr. President, and each of the distinguished members of the court for their kind attention to our presentations. May I also offer our sincere thanks and appreciation to the court's registrar, to its staff, to the interpreters and the translators, and to all the court staff who have worked hard to ensure the smooth running of these hearings. Thank you very much.
I thank the agent of Pakistan. The court takes note of the final submissions which you have just read on behalf of the Islamic Republic of Pakistan. This brings us to the end of this week-long hearings devoted to the oral arguments in the case. I would like to thank the agents, counsel, and advocates of the two parties for their statements. In accordance with usual practice, I shall request both agents to remain at the court's disposal to provide any additional information the court may require. With this proviso, I declare closed the oral proceedings in the Jadhav case. The court will now retire for deliberation. The agents of the parties will be advised in due course as to the date on which the court will deliver its judgment. As the court has no other business before it today, the sitting is now closed. Thank you.